Welcome to the LexIslamica Law Course video series brought to you by the Advanced Legal Studies Institute, Islamabad. This course, Islamic Law, Finance and Commerce, is the second course of the series. If you haven't seen the introductory video to the course, it is advisable that you do so to get a better idea of the structure and nature of the course. The link for the introductory video has been given in the description below. This video, The Concept of Riba According to the Muslim Jurists, is the second video of the course. Let's begin. We will first talk about Muslim jurists. Who are the Muslim jurists for the purposes of this video? We will distinguish Muslim jurists from modern scholars. Some people become confused when we state that there is consensus on the prohibition of riba. If there is consensus, then why have scholars reopened a finally settled issue? The method of the jurists in interpreting this prohibition and on understanding the issue of riba in general is different from that of the modern scholars of this century. Our focus on this video will be on the method of the jurists. As a method of the jurists can become quite complex, we have tried to simplify things by considering only a few crucial texts. As stated, the method of the jurists is different from that of the scholars, and each group has its own fundamental assumption on which their method is constructed. To explain the method of the jurists, we will consider a single verse of the Quran, which we consider vital for this topic. Once we have explained the verse, we will turn to the Sunnah for the prohibition of riba. Who are the Muslim jurists? By Muslim jurists, we mean the earlier jurists of different Sunni schools of law, who wrote in the first 7 centuries of the Hijrah. They are the jurists whose manuals of fiqh tell us what is meant by Islamic law. There were many jurists in the first 7 centuries, but we are concerned with those jurists whose manuals of fiqh have become popular within the schools, or they are well known for deriving laws and issuing fatwas. The period in which these jurists live may be extended from the 7th century, so as to include certain outstanding jurists, up to the 12th century of the Hijrah. These jurists were authors of certain important manuals of fiqh in later times. Many manuals of fiqh were produced after the 7th century, but only a few of them qualify for the category called earlier jurists. For example, one famous writer in the Hanafi school was Ibn Abidin. In the Shafi and Maliki schools respectively, we have famous jurists like Ramli and Karafi. These earlier jurists are also referred to as the classical jurists, for they were indeed jurists of the highest rank, being the true authorities for the interpretation of the legal texts of the Quran and the Sunnah. There have only been 2 or 3 such jurists in each century from each school of law. When we say that these jurists were the true authorities for the interpretation of the Quran and Sunnah, we wish to deny this status to the writers of tafsirs, for they were not the true authorities for interpreting the legal texts. Is there a consensus on the prohibition of riba? The prohibition of riba is explicit in the texts of the Quran and the Sunnah, therefore it does not need any types of consensus. Anyone who reads the verses will say riba is prohibited. Ibn Abbas, God be pleased with him, is reported to have said, "Verily, riba is in nasiya, delay," probably implying that there is no riba in the other type called fadl. He later retracted this statement. Consequently, Imam Sarakhsi says, "From this we come to know that there is total consensus on the prohibition of excess, tafadul, in the first period, and the judgment of a qadi that goes against this is null and void." This means that riba of all types is prohibited, the first due to explicit prohibition, and the second due to the binding clarity brought in by ijma. Thus, the issue cannot be reopened by any judge, lawyer, or scholar today. So, how then have modern scholars reopened this issue? Let's move to the next slide. Why then have scholars reopened a settled issue? If there is definitive clarity of meaning and ijma that all types of riba are prohibited, then what are modern scholars discussing? The decision was reopened by an Egyptian scholar, Rashid Rida, in violation of this certainty and ijma to justify the decision of the government that interest paid on post office savings accounts was lawful profit. He probably attributed his ruling to his teacher Muhammad Abduh. Modern scholars in some courts, not to be included in the category of jurists, have since been discussing the issue of riba and its legality to prove, once again, that interest charged by banks is prohibited. Besides the violation of reopening the issue, the method of interpretation of modern scholars for proving the illegality of riba is defective and is different from the method of the classical jurists. In doing so, they started reinventing the wheel. Our focus will be on the method of the jurists. Our purpose in this video is to elaborate the correct method of interpretation used by the classical jurists. The method used by modern scholars will be addressed in the next video. When we say that the method of the modern scholars is defective, it means that Islamic law or fiqh has a unique structure that has been understood and refined by the classical jurists from the start and continued over the centuries. Modern scholars trained in Arabic, economics, finance, or law do not understand or even read the texts of the earlier jurists. Assuming that they know more than those jurists of a bygone age, they interpret the texts and the statements of the jurists on the basis of their own knowledge. This is a mistake. The truth is that they are no match for the classical jurists when it comes to the understanding of the issues of riba and the complexities of commercial transactions. We may mention here that the earlier jurists were experts in commercial transactions and they should not be taken as simple individuals of an earlier age. The method of the jurists simplified. There are 12 verses in the Quran, some are mentioned in the parentheses, that deal with the issue of riba. Out of these, we will take into account only a single verse because this verse is treated as a general principle prohibiting riba. The principle is, that is because they say, sale is like riba, but Allah hath permitted sale and forbidden riba. Please note that the term ba' is also translated as reciprocal exchange, and a general translation is trade. These 12 verses prohibit riba, but the term riba in the verses lacks detail. That is, it is mujmal according to many jurists. The literal meaning of riba is simply excess, which does not help too much in interpreting this verse. So, for finding the detail, we must turn to the Sunnah. There are a large number of Sunan dealing with the prohibition of riba, but we will turn to a single hadith for finding out the detail or elaborating the mujmal term. This hadith is the famous tradition of the 6 commodities related by Ubadah radhiyallahu anhu. There are other versions too. Assumption by the jurists for interpretation. The jurists begin with the assumption riba is found in sales alone. This means riba in the Quran and the Sunnah is of the same type and both sources talk about riba in sales alone. To elaborate this, we say sales are of 4 types: currency for property, property for property, property for currency, and currency for currency. The types include barter, real estate sale, and currency transactions. Please note that in Western law, the term sale is confined to the sale of goods alone, which does not include the sale of currencies. Together, all 4 types are called ba' or reciprocal exchange. For our purposes, the last type of sale or exchange of currency for currency is relevant. It includes loan transactions. In a loan, we say, give currency as loan to be repaid in the same currency after a year. In sale, we will say, sell currency for the same currency with a delay of 1 year. The two are essentially the same. This is a crucial concept for understanding the method of the fuqaha or jurists. The viewer as well as modern scholars must not let the sale of goods terminology influence them, as it hinders the understanding of this concept. Interpretation of the verse on riba. Let's repeat the verse. That is because they say, sale is like riba, but Allah hath permitted sale and forbidden riba. We believe the correct meaning of this verse is the one assigned to it here. The viewer may think about other possible meanings of this verse to answer the question, sale is like riba. Why sale is like riba is answered here. The claim of those to whom the word they in the verse applies is that the transaction of riba is the same as that of a credit sale in which the sale price is increased. Let us first look at the transaction of riba. For that, the loan transaction, A has 100 dinars of gold, which he gives to B for a period of 1 year at 10% interest. After 1 year, B pays 110 dinars to A to complete the loan transaction. Let's move on to the next slide to look at another transaction. We will now compare the loan transaction described in the previous slide to the credit sale transaction here. The credit sale transaction is as follows. A has wheat, which at spot rates is worth 100 dinars. Spot rate means immediate cash payment. If he sells this wheat with a delay of 1 year, his funds will become blocked for this period. Therefore, he is demanding 110 dinars instead of 100. B accepts, and after 1 year he pays A 110 dinars. As in the loan transaction, A gets 10 dinars over and above the value of his wheat. The claim in the verse was, in the credit sale there is an increase over the sale price due to delay, and you call this lawful, but in riba there too is an increase on the loan or currency sale amount due to delay, and you call this unlawful. The response, in other words, is that even if the two transactions are identical as far as the excess is concerned, Allah has permitted one and prohibited the other. In light of this verse, there is no doubt about riba being simple interest as well as compound interest, and that it is prohibited. The verse, however, is too precise. It is perfect as a general principle, but some further detail may be required. For example, a person may say, what if I give a loan in one currency and take back repayment in a different currency? What if I give 100 bags of A-grade wheat to a person and take back 110 bags of A-grade wheat after a year? What if I give 100 bags of A-grade wheat to a person and take back 110 bags of A-grade wheat in the same session of the contract without any delay? There may be other questions. The questions show that some more detail needs to be added to the meaning in the verse. We are not allowed to add to this meaning from our own minds or reason. There must be another evidence from the texts. For additional details, then, we have to search in the Sunnah for an evidence. Interpreting the Sunnah on the prohibition of riba. While looking at the Sunnah, the viewer has to keep in mind that the word riba in the Quran was mujmal or unelaborated, and it is the Sunnah now that will bring greater clarity. It will also answer some of the questions raised in the previous slide. The tradition that governs the prohibition of riba is from Ubadah ibn as-Samit Raziyallahu anhu, who said, the Messenger of Allah, peace be upon him, said, gold for gold, silver for silver, wheat for wheat, barley for barley, dates for dates, salt for salt, like for like, equal for equal. That is in equal weight or measure, and from hand to hand. If these species differ, then sell as you like, as long as it is from hand to hand. This is the well-known tradition of the 6 commodities. It governs the rules of riba, currency transactions, loan, and other contracts. Out of these, we will study only those rules that pertain to riba in gold and silver, that is in dinars and dirhams. Imam Ghazali says that selling silver dirhams for identical dirhams is similar to the act of putting the dirhams on the ground and picking up the same dirhams. Contrary to what some may believe, the tradition is not telling us to sell the 6 commodities or not to sell them. All that it is saying is that in case you do decide to sell this way, these are the rules. What then are the rules? According to Imam al-Sarakhsi, there are 2 rules in this tradition. The first rule contains a command that applies when gold dinars are exchanged for gold dinars with a delay and excess. The second rule contains a command that applies when gold dinars are exchanged with silver dirhams with a delay and excess. We will elaborate these rules through diagrams. The transaction shown below is that of the loan transaction discussed on slide 10. The application of the first rule. A pays 100 dinars to B by way of loan for a year on 10% interest. After 1 year, B pays 110 dinars to A. When the two persons, A and B, are seen undertaking the above loan with interest transaction, the first rule with the following command is activated. Make the two values equal in exchange at once. This means that interest cannot be charged, nor can there be any delay. The application of the second rule, assuming that 1 dinar is equal to 10 dirhams, let us assume that the parties agreed to an exchange rate of 1:14. A pays 100 dinars to B with a delay of 1 year. After 1 year, B pays 1400 dirhams to A. A little reflection will show that the above diagram is describing a loan transaction. The command in this case is exchange at once. The tradition does not bother about the excess here, saying, when the species differs, sell as you like, as long as it is from hand to hand. In other words, no delay is allowed. In the first diagram, where the same species or gold for gold are exchanged, there are two kinds of riba involved. This is like an economist saying interest is rent for money. The first type is riba due to delay, called nasiya or nasa, and the second is rent for it, called riba al-fadl or the excess. Just like you would use someone's house or car for 1 year, you need to pay the rent for the period of use. Using the house or car for 1 year is nasiya and the rent paid is fadl. The benefit of use is going to one person, and in return for it, the fadl is going to the other person. In the second diagram, where different species or gold for silver are exchanged, there is one kind of riba involved. This is the case where the economist would use terms like leverage and using the other guy's money. This is called nasiya or nasa. The excess is ignored. That is, the fadl is ignored, because no reasonable man will give another person 1400 dirhams for 100 dinars when the rate is 1:10. We have now reached the end of our brief explanation about the concept of riba according to the jurists. We may now turn to our final conclusions. Concluding remarks about the prohibition of riba. The jurists make the assumption that riba exists in sales alone and that riba in the Quran and the Sunnah is the same. The verse of the Quran studied showed that although to an economist or a corporate lawyer, a loan transaction with interest may appear similar to a credit sale, bay' muajjal, in which the price has been increased due to delay, Allah has prohibited the loan with interest and permitted the credit sale. The Sunnah then gives us the details of the fundamental rule in the verse and points out that certain rules and constraints have to be observed, just in case the interest-bearing loan transactions are conceived or intended. The viewer may have a large number of questions after viewing these slides, but everything cannot be answered in a single video. We will do so in the forthcoming videos on the subject. Thank you.